Ever wondered how a nation's government operates without a single, codified rulebook? Welcome to the fascinating world of constitutional conventions and formal laws, where unwritten traditions hold as much sway as parliamentary statutes. This deep dive will illuminate their critical distinctions and why understanding them is vital for any engaged citizen or legal scholar. Constitutional conventions are the unwritten, non-legal rules that guide political conduct within the UK's uncodified constitution. They are the established practices that ensure the smooth, responsible functioning of government, shaping how key actors behave. Think of them as the gentlemen's agreements of statecraft. These conventions are not legally enforceable by courts, which recognize their existence but cannot compel adherence. Instead, their observance is maintained by powerful political pressure, professional ethics, and the expectation of responsible governance. This flexibility allows them to adapt and evolve with changing political landscapes. A prime example is the monarch's obligation to grant royal assent to all legislation, a practice unbroken for centuries. Another is the convention that the Prime Minister must be a member of the House of Commons, ensuring democratic accountability. These unwritten norms are the bedrock of political stability. In stark contrast, laws are formal, codified rules established by Parliament or the courts, carrying the full force of legal authority. They are binding on all individuals and institutions, enforceable through the judiciary. Laws provide the predictable framework for governance and societal order. Breaching a law results in clear legal sanctions, from fines to imprisonment or the invalidation of actions. Laws are typically written in statutes or case law, offering clarity and certainty regarding their scope and application. Their creation follows defined legislative processes or judicial precedents. Consider the Human Rights Act 1998, a statutory law that incorporates the European Convention on Human Rights into UK law. Similarly, the requirement for Parliament to meet annually is a statutory provision, not merely a convention. These laws form the explicit legal backbone of the state. The fundamental difference lies in enforceability and origin. Conventions emerge from practice and tradition, maintained by political pressure, while laws are created through formal processes and are legally binding. Conventions supplement legal rules, guiding political actors, whereas laws provide definitive, enforceable regulations. For instance, the convention that the monarch acts on ministerial advice ensures democratic accountability, but it is not a statute. Conversely, the Parliament Acts of 1911 and 1949 are statutory laws defining the powers of the House of Lords. Understanding this distinction is crucial for analyzing constitutional power. Courts have consistently affirmed the non-legal status of conventions, even while acknowledging their political significance. In Madzimbamuto v. Lardner-Burke, 1969, the Privy Council ruled that conventions do not limit Parliament's legal powers, emphasizing that courts enforce law, not political custom. Similarly, the Supreme Court of Canada, in reference re-amendment of the Constitution of Canada, 1981, recognized the importance of conventions but declined to enforce them. These landmark cases underscore that while conventions are vital for political practice, they remain outside the realm of judicial enforcement. Let's consider practical examples. The Sewel Convention dictates that the UK Parliament will not normally legislate on devolved matters without the consent of the devolved legislature. While politically significant, the Supreme Court in Miller, 2017, confirmed it is not legally binding. In contrast, the Fixed-Term Parliaments Act 2011, though now repealed, was a statutory law that set a fixed parliamentary term. This demonstrates how a political practice, like calling an election, can be codified into law, transforming its nature from a convention to a legally enforceable rule. Constitutional conventions and formal laws, though distinct, are two indispensable pillars supporting the UK's unique constitutional framework. Conventions provide the flexibility and ethical guidance for political actors, while laws offer the certainty and enforceability essential for a stable society. Grasping their interplay is fundamental to understanding the intricate dance of power and responsibility in a modern democracy. We encourage you to delve deeper into these fascinating aspects of constitutional law. Share your thoughts in the comments below, subscribe for more insightful analyses, and explore our other resources to further your understanding of governance and legal principles.